In November 2023, lawyers in Canberra were waiting on High Court judges to review a major pillar of Australian law, indefinite immigration detention. Those lawyers and the government expected it to take months for 7 justices to come to a decision on the controversial topic. But after just a 16-minute break, Chief Justice Stephen Gageler and his colleagues tore down a central pillar of Australia's immigration system that had been in place for 20 years. The government was caught off guard, so too those lawyers in the court, just at how quickly the High Court had ruled.
We're talking about some very serious criminals here, pedophiles and rapists, murderers.
If I had any legal power to do it, I would keep every one of those people in detention.
Months on from that, government ministers are still scrambling to reassert their control of the borders.
I'm so sorry, I've got to go to a meeting.
But what was behind this decision? What does it mean for the people in immigration detention? And how is the government handling this? The case surrounds a Rohingya man from Myanmar, known in court as NZYQ. He arrived in Australia by boat in September 2012, had his refugee status recognised, and then received a visa to stay in Australia. NZYQ lived in the community until he was arrested and charged with raping a 10-year-old boy in January 2015. While detained, the government cancelled his visa on character grounds. He pled guilty, went to jail, and was released on parole in May 2018, only to be immediately detained because he didn't have a visa to remain in Australia. The government freely accepts that NZYQ is a refugee and unable to be sent back to Myanmar, but unable to find a third country to send him to and unwilling to issue him a visa to stay in Australia, his future looked to be in immigration detention indefinitely. That is, until his case reached the High Court. In order to secure his release, NZYQ's lawyers had to convince the court it had wrongly decided a case 20 years earlier. That case, known as Al-Kitab, saw the court rule with a 4-3 majority that indefinite immigration detention was lawful. That brings us until November 2023, and after a 2-day hearing, the High Court agreed that Al-Kitab had been wrongly decided and took the rare step of overturning 2 decades of legal precedent. That alone would have been a big deal, but how the court made its ruling is what proved the biggest shock. Typically, the High Court will hear a case, maybe over a day or two, and then adjourn to consider its ruling and reasons. But Chief Justice Stephen Gageler, just 3 days into that job, shocked both the government and the lawyers in the court when he immediately announced a ruling. Not only did the court say that indefinite immigration detention was unlawful, it also immediately set a new test for determining if a person should be released or not. That test is there a real prospect of removal from Australia becoming practicable in the reasonably foreseeable future? In other words, will another country take this person in the foreseeable future? If the answer is no, the person can't be detained any longer. The reason this is such a big deal is twofold. Since Paul Keating's Labor government changed the law in 1992, it has been mandatory for unauthorised arrivals to head into immigration detention. The Al-Kitab ruling in 2004 reinforced that it was legal for people to remain there indefinitely, and future Labor and coalition governments have supported that. These policies have left hundreds of people in immigration detention, denied visas to enter Australia and unable to be sent home for a range of reasons. Secondly, and perhaps more immediately, this was bigger than just one person being released into the community. It meant that anyone in immigration detention, when faced with that new test, if there was no real prospect of being removed in the foreseeable future, then they had to be freed. That's why the ruling has prompted the release of almost 150 people from immigration detention. The government has been tight-lipped about their backgrounds, but we do know the cohort includes violent offenders, kidnappers and robbers, sexual offenders, domestic violence and stalking offenders, drug traffickers, murderers and people smugglers. There's also fewer than 5 who have committed low-level or no criminality. While the coalition accused Labor of releasing more people than it should have, constitutional law experts dispute that. They argue the government had no option but to follow the court's new ruling. With nowhere to send them and it now being unlawful to keep them detained indefinitely, the government released the detainees on strict visa conditions into the community. In the 5 months since the High Court's shock ruling, there's been no shortage of rushed legislation that's been pushed through the Parliament, in most cases with the coalition's support. First up, there were strict visa conditions that were rushed through the Parliament. That meant people had to adhere to curfews between 10 p.m. and 6 a.m, wear ankle bracelets, and face criminal penalties, including possible jail for breaching visa conditions. Almost as soon as some were released, they were back in trouble again over theft and assault charges. For others, they launched legal threats against the curfews and ankle bracelets, and the government quietly removed those conditions to prevent the cases going further. It also emerged this year that detainees had been put on invalid visas, meaning charges were dropped against those who were in trouble for breaching their visas. But the government insists those facing other charges like theft and assault will still face prosecution.
This will not affect any offences conducted under state or territory law.
We've also seen the creation of a preventative detention regime based on existing terrorism laws. Judges now have the power to impose detention or supervision orders on a non-citizen previously convicted of a serious violent or sex crime if the government can show there is a high chance of community harm. The High Court has previously deemed similar terrorism laws legal. But it's also a high bar that the government needs to pass to get one of these orders. A lot has happened since the High Court ruled indefinite immigration detention was unlawful. But this story is far from over. There are cases now working their way through the courts which will determine the finer details of the NZYQ ruling. Things like, what exactly does no real prospect and reasonably foreseeable future mean in that new High Court test? There are other cases too that could see more people released from immigration detention. It's not just refugees and stateless people the government has struggled to deport. Iran has a policy of not accepting their citizens if the person doesn't want to return. To counter that, the government tried to rush extraordinary immigration powers through the parliament to compel people to cooperate with deportation. The government also wants the power to outright ban people from certain countries from coming to Australia in the first place. Labor wanted to rush that through the parliament within 36 hours, but it had it blow up in its face when the coalition initially refused to back it. A Senate inquiry is now looking at the proposed laws and will report back in May, but even Labor's own backbench has been critical of the rushing. It might have taken the High Court just 16 minutes to overturn indefinite immigration detention, but it's taking much longer for the government to reassert its control over not just who can come to Australia, but who gets to stay here.